all. My name is Iram Khan and I'm an MPhil student. I welcome you all to this seminar on recent developments in international law. This seminar is organized in the memory of Professor R.P. Anand and in the memory of all other teachers around the world who are not with us today. I would request all of you to please stand up and observe a 2-minute silence in the memory of Professor R.P. Anand. Professor R.P. Anand, I hope and pray that he continues to inspire us to reach new heights every day. Welcome every morning with a smile. Look on the new day as another special day from the Creator, another golden opportunity to complete what you were unable to finish yesterday. Most Honorable Dean, Faculty of Legal Studies, Professor Yogesh Tyagi, most respected Chair, Professor Ermin Rosenkrantz, eminent speakers of the day, adorable teachers, my fellow students, ladies and gentlemen, I once again cordially welcome you to this seminar on recent developments on international law. Today's session is chaired by Professor Ermin Rosenkrantz, who has been associated with Professor R.P. Anand for a very long time. Professor Rosenkrantz is a visiting professor at the General School of Government and Public Policy. He's been associated with University of Virginia. He has been a consulting professor of international relations at Stanford, a visiting professor, Georgetown Law Center, London Summer Program. He carries with him a truly global experience. We all have read his book on environmental law, which is a leading book on the subject. It's an honor to have you here, Professor. We are also delighted to welcome all the speakers of the day. We have with us Professor Stephen P. Marks, who will give a presentation on proliferation of rights in international law and proposals for bounding the right to health. We have Professor M.P. Singh, who will present on constitutionalization of international law. Professor C. Raj Kumar will give a presentation on corruption and governance. Professor Manoj Sinha will present on international human rights law. Thank you all for being here. It's a sheer privilege. We all look forward to hear from you. Now, I would like to hand over the mic to Professor Ermin Rosenkrantz to moderate the session. Thank you.
Hello. Okay. I'm Ermin Rosenkrantz, and I first met Professor Anand and also Professor Tyagi 30 years ago in the wake of the Bhopal tragedy. Professor Anand and I spoke at a panel, and we had the same view of the Bhopal disaster, which was that people were asking for way too little money, more like $500 million. He said we should be asking at least for $3 billion, 6 times the amount, $3 billion. And he said, I remember him saying, $500 million is a pittance. It doesn't amount to much. Well, unfortunately, and then Professor Tyagi and I wrote about some of the international law aspects of the Bhopal tragedy, but the pity of it was that may all recall this. The justices, or the law minister, was in charge of the Bhopal litigation. And Union Carbide had the money and the wherewithal to hire the best, the ablest, the most expensive Indian lawyers. So it wound its way through the lower courts and the appellate courts, and the judges of the Supreme Court sitting in Delhi said, this is not going to work. This is going to embarrass us, because these lawyers, although Indians, are way too experienced to for our lawyers in the law ministry to be able to contend with them. So the justices of the Supreme Court sat down in 1989, 4 years after the tragedy, 4.5 years after the tragedy, and they brokered a settlement which was close to the pittance that R.P. Anand was talking about. $500 million, $470 million. And they only later realized how little money this was. The money didn't get distributed until 5 years later. And the person who distributed it took 30 seconds per case. Loss of limb, so many rupees. Loss of life, so many rupees. Loss of eyesight, so many rupees. And that's the way it went. For this man bragged to me that it took 30 seconds. 30 seconds for each case to be decided. And it didn't cover the future. The birth defects, genetic problems that will last probably for 3, 4, 5 generations from taking in all this contaminated gas from the gas leak. Anyway, that's what it is. Let me just also say a word about developments in international law, because I've been talking about this for a while. One of the major developments of international law that you need to that you wouldn't ordinarily think about is the role of the United States, which is a scofflaw, basically, rejects all international law, rejects supposedly the law of the sea, rejects the International Criminal Court, all the criminal proceedings internationally, rejects the Kyoto Protocol, a whole series of things that the United States will not participate internationally. But there is really a new era, because there are some things that can't be done outside of the international community. You can't, for example, deal with global commons, Antarctica, the high seas, outer space. These are something you have to. Chemical and biological warfare, climate change. None of this can be done country by country, even though we have been for 350 plus years dealing with the nation state being the sovereign entity in the world. But now we have complex international problems that demand international solutions. Climate change. It comes from all over the world, contaminates the entire planet. So we have to resort to international law. The United States and China, interestingly, are the two countries that resist international law. They talk about sovereignty, and they need control over anything that happens within their jurisdiction, notwithstanding the international flavor of some of these issues. So I think it's worthwhile to look at the compromises that the United States and China have made in the field of climate change, particularly China in the field of climate change, and the United States as well. The United States and China have now come to an agreement on climate change, which may set the tone for a whole new readiness, preparedness for change in this area, for international agreement. But also, the United States, you should look at the single institution in the world that is international, and the United States observes it to the letter, and that is what? The World Trade Organization. The World Trade Organization is got the compliance to the letter by the United States and by all other states. All the dispute resolution panels of the World Trade Organization supersede anything the United States might have developed on its own. So that's an important thing. And also the global commons. The global commons, Antarctica, the high seas, outer space, has also come under compliance by the United States is a member of, not quite a member of the law of the sea, but observes the law of the sea, observes all its provisions, is part of the Arctic Council, which is a unit of the law of the sea, is part of the Antarctic Protocol of 1990s. So that's important to remember. And finally, there is an Indian addition to this whole international set of problems, and that is the public trust doctrine. The public trust doctrine has been taken over by Indian judges as though it were made by themselves. It actually comes from a case in the United States in about 1900, more than 200 years ago, or 115 years ago, but it is now referred to by High Court and Supreme Court judges as taking over. The public trust doctrine applies to water, applies to, which is what it originally applied to, water under rivers, land under rivers and streams and lakes, and baylands, but also now it takes in air, it takes in protected areas of land, and some people are saying, some judges are saying it also takes in wildlife. So the Indian imagination is to take this doctrine, which originated in the United States so many years ago, and apply it to cases before them today. This is the public trust doctrine is something you should hear about and pay attention to. Okay, now I'd like to introduce my colleague and travel mate, Professor Stephen Marks, who, as you know, is the Francois Xavier Bagnou Professor of Health and Human Rights, Director of the Program on Human Rights and Development at the Harvard School of Public Health. And he's also Special Advisor to the Vice Chancellor of O.P. Jindal University. Professor Marks.
And I've chosen as the topic something that does not sound recent at all, which is human rights. It's an old topic of international. That's this. Okay. It's an old topic of international law. Universal Declaration of Human Rights, 1948, 30 articles. There we are. What is the novelty? What is the recent trend that is worth devoting our attention to today? This one over here, is that right? There's proliferated a number of human rights. How do we quantify it? It's a large number of human rights. I'm going to get to the quantification of that in a little while. The question that I want to reflect upon is whether the proliferation of international human rights, the norms that are defined or claimed to be internationally recognized human rights, weakens international law. Because instead of 30 articles of the UDHR, there are hundreds, if not thousands, of normative statements that are claimed from various sources to be human rights. Wouldn't this proliferation dilute the corpus of international human rights and reduce human rights to being mere wishful thinking, rhetoric, without the legal significance of what an international norm should be? I'm going to get this to work sooner or later. I press this and nothing happens. This one. Okay. Now, there's nothing new about bemoaning the proliferation of rights. The Universal Declaration of Human Rights is one modern source of claiming what are the human rights. We can go back a few more centuries to the French Declaration of the Rights of Man and the Citizen and find that soon after its adoption, the gentleman sitting there in this little cabinet, and that is the body of Jeremy Bentham, considered that these rights proclaimed in there were rhetorical nonsense. Nonsense upon stilts. And that wasn't enough for him to just call them nonsense upon stilts. He called them mischievous nonsense, dangerous nonsense, miserable nonsense, rueful nonsense. And he said the language in which these human rights norms, the French Declaration of the Rights of Man and the Citizen, are terrorist language. Well, today we're, of course, looking all over the place and finding terrorist language. Are the human rights as they are proliferating part of terrorist language? That was in the 18th century. More recently, Francis Fukuyama, for example, Francis Fukuyama described the human rights movement as creating monumental confusion. Over the past generation, he wrote, the rights industry has grown faster than an internet IPO in the late 90s. In addition to animal, women's, and children's rights, there are gay rights, rights of disabled and handicapped, indigenous people's rights, right to life and right to death, rights of the accused, victims' rights, and the famous right to periodic vacations. If you don't know what that means, the famous right to periodic vacations is among traditional U.S. lawyers, that is usually the human right that is signaled out to show how silly the human rights framework is, because they even consider that a paid vacation is a human right. But we don't have to go back to the early 90s to find Francis Fukuyama saying that. It is echoed in an article that appeared just a short time ago by Pablo Pisano in Foreign Policy, in which he said, today we have a surplus of human rights, and they're all claimed to be equally important and indivisible. Human rights are going nowhere. They have lost their value. We may be witnessing the slow bursting of the human rights bubble. Again, taking that analogy that Fukuyama had of the IPOs of the 1990s, the bubble is bursting. Too many human rights. There is human rights inflation. It is harmful. Now, I'm going to use as an example of the topic of how human rights, the normative content of human rights grow, and I'm going to make a proposal for containing that growth, limiting that growth in certain ways that may be useful for recent development of international law. And in doing that, I want to continue in this theme of people who have voiced a strong criticism of the proliferation of human rights. Excuse me, by citing an article in the Journal of the American Bar Association. The journal is called Human Rights. It's focusing on human rights. And here the example is the case against making healthcare a human right by Lamb, who claims, former governor and a lawyer, distinguished lawyer, who says it is problematic to consider healthcare as a right. If everything is a right, arguably nothing is a right. We can easily dilute the important meaning of the word by claiming idealistically that all good things are rights. Now that's the big challenge for the proliferation of rights, isn't it? We would like all good things to happen to people, but does that mean that all good things should be called a human right? Is there a human right to health? And what I'm going to talk about is to challenge you to think. You might spontaneously think water and sanitation, well, that's good, we have to have it. So let's call it a human right. What about safe motherhood? What about tobacco control? What about essential medicines? What about essential surgery? What other items would be on this candidate list for the expansion of the list of human rights? So, my third point is the expanding normative content of the right to health. I'm using this as an example, and I'm going to come back to the general question of the proliferation of human rights. And ask you to think about 3 ways in which human rights become articulated and expand. The first is the familiar one to anybody who works in the human rights field, and if we take the example of the right to health, is a core treaty norm. We know that the International Covenant on Economic, Social, and Cultural Rights in Article 12 postulates the right to health. We also know that it is expanded through the interpretation by treaty bodies and the Office of the High Commissioner for Human Rights. And we're going to look at 6 examples in which, beyond that expansion of interpretation by treaty bodies and the Office of the High Commissioner, academic proposals have sought to articulate new human rights, and I'm putting new in inverted commas. Let's take as a first example the right to water and sanitation. All right. We all know that the International Covenant on Economic, Social, and Cultural Rights is monitored by the Committee on Economic, Social, and Cultural Rights. And the Committee on Economic, Social, and Cultural Rights in 2002 issued a general comment on the right to water. And in that general comment, it explained how significant water is to the realization of the right to health, how fundamentally important it is to life. Therefore, there is a human right to water as part of the right to health. The international community went farther, and of course, as you know, water and sanitation has become a primary preoccupation of the international community. By 2006, the Human Development Report, the Human Development Report of UNDP was devoted to water, and in its title, Beyond Scarcity, Power, Poverty, and the Global Water Crisis. It articulated the theme of water and sanitation as being based on the recognition, the significance of the issue is being based on the recognition that water is a basic human right. That was in 2006. In 2010, the General Assembly of the United Nations adopted Resolution 64-292, in which it proclaimed water and sanitation as a human right. So in this case, observe the process that has taken place in this recent development in international law. We have gone from a human right to health that appeared in the Constitution of the World Health Organization, a treaty, in the Universal Declaration of Human Rights, a normative standard and aspirational statement for all of humanity, in the Covenant in Article 12. No reference was made to water and sanitation at all. The committee interpreting Article 12 said, water is fundamental, water is essential, water is part of the right to health, it must be a public good. Then, this right, which was never in a treaty as a human right, became so important to the international community that the General Assembly was willing to proclaim it as a freestanding right. Not a right that's derivative of the right to health, but a freestanding right. So here's an extraordinary recent development in international law. You have a concept. Human beings need water and sanitation. You have a growing awareness of it. You have the total absence of the word in the human rights instruments themselves, in the positive law. You have a reference to it in the interpretation, and then it becomes a full-blown right in a declaration of the General Assembly and fairly wide acceptance. This is General Comment 15, and now I move to the second example of a way in which references to a significant health issue has been reformulated as a human right, again, as a recent development in international law. Safe motherhood was early articulated as being a public health need that would best be met by applying human rights. The implementation of various human rights in national and international laws relevant to the reduction of unsafe motherhood and to enable women to go through pregnancy and childbirth safely. In this articulation, formulated in numerous articles by Rebecca Cook and others who wrote this document for the World Health Organization, Advancing Safe Motherhood Through Human Rights. Now notice the difference. The first example, water became an autonomous human right, having been first recognized as fundamental to the right to health. Here, safe motherhood is recognized as human rights relevant and to be achieved by attaching greater attention to the ways through which human rights can enhance safe motherhood. So, a link that leads one to easily say there is a human right to safe motherhood. But that's merely a shorthand for saying human rights will help achieve safe motherhood. Here's how, in the book that you see there, explains how. Third example, tobacco control. A few years ago, I co-authored an article called The Emerging Human Right to Tobacco Control. The picture on the left is for comic relief because there is also a movement of smokers' rights that declares International Smokers' Day, and they have a universal declaration on the rights of smokers, which is a total distortion of the human rights framework, but I won't take time on that. And you have several articles that have articulated tobacco control, which can save 5 million lives, 5 million preventable deaths per year through tobacco control, is on such a scale that it is inconceivable to have a policy of realizing the right to health unless there is adequate attention to tobacco control and in particular to compliance with the Framework Convention on Tobacco Control. So in this case, tobacco control is acknowledged as integral to the right to health. Or, in a shorthand term, the emerging human right to tobacco control, by which we don't mean, like the right to water, a freestanding right, by which we mean that the right to health is inconceivable unless tobacco control is an integral part of it. Fourth example, the right to essential medicines. We all know the controversy surrounding the TRIPS agreement and the utilization of patents to protect the pricing of medicines that prevent, in particular, people living with AIDS from receiving antiretroviral treatment at affordable prices. India is, of course, in the forefront of developing generics in this area and dealing with the tension between the intellectual property regime and the international human rights regime has led to a trend of articulating access to medicines, medical products, vaccines, and medical technologies as a human right, the right to essential medicines. But in fact, like the previous rights that we examined, that's a shorthand for what we really mean is that there is a derivative right from the right to health. If the right to health is going to be implemented in the case of people who will die unless affordable medicines can be made accessible to them at an affordable price, then the human rights regime enforces an increased access to affordable medicines as an essential component of or as a derivative of the right to health. Fifth example, in all of these cases I'm showing you examples on the screen of publications that have articulated in detail how the right is implemented in practice, what it means, what its definitions are, and how we establish that nuance between a human right to essential medicines and essential medicines as a derivative right of the right to health. So understand this floating between right to and derivative right of. Fifth example is essential and emergency surgery. Kelly McQueen and her co-authors wrote a splendid article in the Journal of Health and Human Rights in which they articulated quite clearly that essential surgery is integral, even in the title, as integral to the right to health. The same argument as the previous one. There is a right to essential and emergency surgery, in other words, those affordable means that can save lives, that all health systems must make available, C-sections being the primary example that is often cited, that can lead us to argue that there is a right to essential emergency surgery, by which we really mean that these interventions are integral to the right to health. A right to health is not fulfilling, a government is not fulfilling its international obligation under the right to health unless and until essential emergency surgery is part of the package. Now, in the same flow of academic publications that have articulated human rights, I came across in the Journal of Cystic Fibrosis an article claiming a right to newborn screening for cystic fibrosis. And as you can see, the author asks in his title, is newborn screening for cystic fibrosis a basic human right? Well, this is a doctor who considers that under certain circumstances, newborn children must be screened for cystic fibrosis. The technology is available and affordable, and the dangers are so high that this rises to the level of that. And I'm citing this as an example at the opposite extreme of the 6 examples I've given, from the right to water example, where there's no hesitation to move from integral to the right to health to freestanding right. Here, I don't think anybody is going to say anything more than screening for cystic fibrosis is an intervention in health that should be made available when a public health system is being implemented in ways that are consistent with the state's obligations to realize the right to health. But a freestanding human right is a bit of an exaggeration here. So here's what I'm getting at. And if we're going to do this in terms of new developments in international law, does this? Yes, it does reach here. Okay. If we look at the source of a human rights standard, its legal nature, and the component elements of the right to health, we can start with the WHO Constitution, which is a treaty, the preamble of which says that the enjoyment of the highest attainable standard of health is a fundamental human right. That's a treaty. That's an organic treaty. All members of the World Health Organization have accepted that definition. The UDHR considers that as part of the standard of living is the right to adequate health for oneself and for one's family, including medical care. That's a GA resolution of a particular normative character because it's in the form of a declaration that has acquired particular significance, but it is not a binding treaty. The International Covenant on Economic, Social, and Cultural Rights is a core treaty norm articulating the enjoyment of the highest attainable standard of physical and mental health as a human right that is that the states parties to the covenant are bound to realize. Now, here's where it gets interesting, and here's where I'm talking about new developments in international law, and I'm going to conclude in a minute. If you take the text of the International Covenant on Economic, Social, and Cultural Rights, in Article 12, it does articulate in paragraph 1 this core right, enjoyment of the highest standard of physical and mental health. In paragraph 2, it articulates illustrative steps that must be taken to deal with infant mortality, with industrial hygiene, with various types of diseases, epidemic and endemic diseases and so on. So we already have, in the text of the treaty itself, an expansion. It's right to physical and mental health, yes, but it's illustrative steps. Here's a list of 6 things that must be done. Next step, as I already referred to, General Comment 14 of the Committee on Economic, Social, and Cultural Rights lists essential elements of the right to health. And you can see them listed here. The essential elements of the right to health, by which the committee said, as we read reports of states parties to the covenant in their efforts to comply with their obligations under Article 12, this is what we expect them to include. This is what we're going to judge them on. So you can see that the normative content is expanding considerably by the body empowered to judge it. And it added, in addition to these essential elements, it added a core minimum that includes adequate supply of safe and potable water, overlapping with the right to water, shelter, housing and sanitation, public health, can't read that quite from here, and plan a strategy for achieving and extending a public health system. All of these component elements are what governments are required to do under the core minimum as defined by the Committee on Economic, Social, and Cultural Rights. But that wasn't enough. It went a step further in General Comment 14 and included obligations of a comparable character to the core minimum. Again, the expansion of the right to health by the committee. Now, we get to the definition of attributes that was provided by the Office of the High Commissioner for Human Rights, and our colleague Rajiv Malhotra is the principal author of this, in which 3 attributes of the right to health were defined. This has considerable authority coming from the experience of the Office of the High Commissioner for Human Rights and in an official publication of the organization. Then we have the articles that I was referring to that attempt to articulate where in this framework do we place safe motherhood, tobacco control, essential medicines, essential surgery, and cystic fibrosis. Conclusion. We can see that there's a normal process for this particular human right, the right to health, and the equivalent can be done for other human rights that have started from a core norm, have expanded through interpretation, which is lex lata. From the point of view of international law, this is established law. The lex lata are the core treaty norms and General Assembly resolutions, to which we can include the resolution on the right to water. So there is a human right in established law to physical and mental health and to water and sanitation. Established. De lege ferenda, the normative content of human rights is expanding through these illustrative steps, essential elements, core minimum, equivalent obligations, attributes. At the same time, academic proposals are sometimes articulating new human rights, in which they say there is a human right to tobacco control. There is a human right to safe motherhood. Now, these are meaningful not as proliferation of rights in which the criticisms at the beginning, these are diluting of rights, they're dangerous, they are harmful, but as a shorthand for advocacy purposes, meaning that the obligations of states under the right to health include clear obligations to realize these public health goals as integral components of the right to health. So that's the point that I'm trying to make here, is that the right to health has expanded immensely from the starting point in the Universal Declaration of Human Rights and the Constitution of the World Health Organization. However, we need to be careful to avoid falling into the trap of the proliferation of rights and utilize the right to and new human rights carefully so that we make it clear that this is a shorthand for saying, actually, we acknowledge there is a right to health, and a right to water, within which there are integral components that we sometimes call new human rights, but by which we really mean they are integral components of the right to health. In this way, I feel we can bound the right to health. We can establish limits to the right to health so that it doesn't fall into the trap of excessive proliferation that was denounced by the quotations that I gave at the beginning of this talk. There is my point. Thank you very much.
Sir M.P. Singh, who will talk about constitutionalization of international law.
For inviting me to speak. And I'm grateful to Professor Tyagi and his colleagues for having invited me. When I got a mail on behalf of Professor Tyagi, for speaking on this occasion, I had my dilemma for the simple reason that I have never been a student of international law. And since it is a event on international law, how shall I justify my participation there? But there were two compelling reasons for my coming over here. One was that the event was being organized in the memory of a great human being and a great scholar, Professor Anand. I came to know Professor Anand very late, though of course I had heard his name. I knew that he is a famous scholar of international law in our country. Yet my meeting was very late when he had already retired from the university and was working for some time in the Max Planck Institute at Heidelberg. There we met and I realized how good a person he is and how much respected as a scholar in international law he is. Since then there were quite a few occasions when we met, and I am glad that after his death we have decided to have this meeting, and therefore I thought that I must go. The second reason was that I could guess that the event is being organized among persons of different institutions, and I have always cherished that the deficit of comparatively less meeting and less scholarship among the legal scholars, that should somehow be met. And for that reason, I thought that I must become part of it, irrespective of the fact that I have no idea of the subject and may not be able to speak on it. But then when I agreed, I thought that let me think of something on which I can relate myself to international law. While going through the legal literature on public law, I found somewhere this caption, constitutionalization of international law. And then I started searching, taking help from friends that I have seen this kind of caption and whether there would be some material available on it. Some materials I found, some materials were searched by friends for me, and it is on that basis that during the last few years, a few days, I have tried to understand the subject, and that I will be presenting to you. It's not going to be a very serious work like that of Marx, but I think it would be relevant to understand unless you have already seriously discussed this subject. constitutionalization and constitutionalism, you already know, you are well aware with constitution and constitutions. A constitution, of course, was not enough unless and until the concept of constitutionalism was developed. And the concept of constitutionalism in general, as you might be knowing, is subjecting the state sovereignty to certain norms or regulations. And among those norms are that people as equals and free participate in the formation of their government and the formation of their laws. Secondly, that the state, which has a monopoly over violence or to control violence, it is its responsibility to ensure that the laws are properly enforced, and therefore they are responsible for maintaining the rule of law. And thirdly, the idea of constitutionalism is also related to the fact that there is a civic solidarity among the citizens of that country towards a certain goal, that is to maintaining harmony within that society. These are general norms which are accepted not only by lawyers but even by philosophers or political scientists, that constitution means that day. And it is in that context that during the last few years, after having established initially League of Nations, which failed, later the United Nations, which has been working for quite some time and has established an infrastructure which ensures at least elimination of wars so far, but always, all the time, somewhere in the world, either within or between the countries, something like a war has been going on. And it is in this situation that the question arises that whether the arrangements which we have made so far through the United Nations, whether those arrangements are lacking in some way. And generally it is said that if the international arrangements could also be organized on the similar lines as the constitutions have been organized, that is, the constitutions also control the sovereignty of the state and puts human beings before the state. That is, the state is for the human beings, not the vice versa or the other way. That it is not that the human beings are for the state. Now, if this kind of arrangement can be made at the state level, whether it is possible to make a similar kind of arrangement at the international level. The UNO, of course, no doubt, has established several institutions, some of which Professor Rosenkranz has already mentioned. But these institutions, as he himself has told us, are not actually powerful enough to compel the nations to be bound by the norms of international law. There are some norms of the international law, which is called as customary international law or general principles of international law, which generally all the states observe as a practice, and for that some kind of consensus has emerged throughout the world. There are some institutions which have been created under the UNO, whether it is World Bank or IMF or it is WTO, which also have some sort of legal power or legal existence. There are also informal organizations like G8, G20, where some kind of negotiations can be worked out among the nations. But whether they would be as effective as the institutions within a state where a constitution has been established, there remains a doubt that so far as the United Nations is concerned, perhaps it does not have that kind of arrangement. And it is because even within the UNO, all these states are not having similar position. It's not like even as a federal arrangement which is created within a country where there is a common constitution which is observed by the central government as well as by the member governments of federal, what may be called as states, regions, or whatever you may call them. Even that arrangement is not satisfied so far as UNO is concerned or present international arrangements are concerned. And it is for this reason, therefore, the question arises that the hope which we had created through the League of Nations, which failed, and the UNO, which is working so far and in a way prospering also, whether that hope can also be belied at some point of time, and whether we can ensure that this does not happen anymore. And for that reason, therefore, whether we can create something like a constitutional arrangement within the state. The German scholars particularly, not only lawyers, but also non-lawyers like Habermas, who is a sociologist but also a philosopher, they have come with the idea that yes, of course, constitutionalization of international law is possible. The individuals within the institutions, like the Max Planck Institute at Heidelberg, they have developed quite a bit of material on these lines that we can make an arrangement, and the model for that arrangement can be the kind of arrangements which the European Union has made for itself, that wherein the states retain their sovereignty, but that sovereignty has become subject to certain common principles, which, for example, in the European Convention of Human Rights, that controls the sovereignty of the member states, and then now the Lisbon Treaty, which is a kind of common constitution for the states, creates a legal structure under which the member states are subject to certain legal norms. Of course, there are issues of crisis so far as the European Union is also concerned, but in course of time it has been found that it is from an economic community, it has in course of times has developed into a kind of political union which can form the basis for an international arrangement. But whether the international human body or societies are so cohesive and so somewhat equal as the European members of the European Union are. And there the answer would be no, that is not true. That the kind of commonness which is there between the members of the European Union and the uncommonness among the countries of the rest of the world, that does not present European Union as a good example to be followed worldwide. Now to that the solutions have been suggested, and the solutions are that just as European Union is a regional supranational arrangement, similarly throughout the world similar arrangements can be made, and then those arrangements may take the responsibility that the kind of strife within the countries or with the countries that take place from time to time today, whether it is violations of human rights within the country, whether it is the problem of terrorism, whether it is the kind of problem which continues to be during the last few years in the Middle East, whether those kinds of calamities can somehow be eliminated or prevented by this kind of arrangement. And the scholars are quite hopeful that so far as two major conditions of constitutionalism are concerned, they can easily be satisfied by having constitutionalism within nations, and those conditions are that as free and equal citizens, the people decide their government and make their laws or participate as equals, and secondly, that there is an administrative arrangement by which rule of law is maintained. By and large, in all countries, to some extent, I am not saying that rule of law is satisfied or maintained even in countries like India fully, but to some extent there is a consensus on these issues. The problem, however, arises with respect to the third aspect, that within a country there is a kind of civic solidarity, or at least there is a presumption that there is a civic solidarity. Which civic solidarity, how shall it be developed so far as the whole world is concerned, or all the societies of the world are concerned? The scholars are not giving hope that that cannot be created. There is a possibility that common values and common understandings may be created in course of time among the nations if we continue to make efforts in that direction and continue to develop arguments which are acceptable to the leaders of the world or the people of the world, who would then make this arrangement, and maybe they are able to convert UNO either into that kind of arrangement, or they may create a new type of model by which constitutionalism will be established throughout the world. I think this is basically the idea, that is to create a stable, peaceful and predictable society for all of us. That's what the constitutionalization of international law requires, and let us hope that with the efforts of all of us, we shall be able to see it either in our lives or maybe definitely in your lives, and hopefully the world would be the kind of ideal we think of it. Thank you very much.
To introduce the Vice Chancellor of JGU, Jindal Global University, Professor C. Raj Kumar.
First of all, I would like to thank Professor Yogesh Tyagi, Prabhash Ranjan, as well as other distinguished colleagues at the Faculty of Legal Studies at South Asian University for inviting me to be part of this seminar organized as a tribute to Professor R.P. Anand. This is, you don't need to switch off all the lights, just maybe one or two lights is good enough. Before I just talk about the subject matter of today's my own presentation, I just want to briefly reflect about Professor R.P. Anand. I think I had the privilege of engaging and meeting and spending some time with Professor R.P. Anand upon the introduction of Professor Yogesh Tyagi several years ago. And one of the most amazing things about this extraordinary man was his humility. His intellectual standing in the world has never created even a modicum of arrogance in him. And that, as a relatively young faculty member in Hong Kong, I began to engage with him, and I felt that that humility and grace is something which, as young people in this room, even as faculty members, we can draw inspiration from. It is needless to say that Professor R.P. Anand's scholarship is world-renowned, and his contribution to not just public international law, but also to the entire framework of developing third world scholarship and focusing a lot on the collective consciousness of the developing world, and to bring that scholarship into the international arena has been a great source of inspiration for many scholars since his own work. Also, it is useful to mention that we in India have unfortunately not been able to recognize, appreciate, and indeed celebrate the contribution of great scholars such as Professor R.P. Anand. I would like to place on record and appreciate Professor Yogesh Tyagi's vision as well as commitment to continue to celebrate and to keep him and his work as part of our collective consciousness. And it is really wonderful that we have the opportunity to do it here. I remember doing this at the JNU itself a few years ago when Professor Tyagi had organized it as a part of the center there, and I'm very happy to see that the tradition that was established then is continuing. It is also an important opportunity for all of us to think that people like Professor R.P. Anand were contributing to international scholarship at a time when it was a pre-internet era. As young scholars today, if we were to pursue research, it is so easy for us to, in many ways, look at work done by others in the field. As students, you have great access to resources. Students in our university also have that kind of a privilege. But Professor R.P. Anand's work and his important contribution happened at a time when these things were not there. It was painstaking, it was extremely frustrating. He operated at little resources in Indian university settings, and that was truly extraordinary, truly inspiring. So I hope that with all the other resources that we all have today, we should be able to draw inspiration from this contribution and make a better contribution in terms of the advancement of research and scholarship and many other things that academic institutions are committed to. What I hope to do in the next, 20 minutes is to reflect about the problem of corruption and the crisis of governance in India. I've been working on this for some years now, and there are certain dimensions relating to international law, particularly in the context of the fight against corruption. But what I intend to do is to simply take you through a set of issues related to corruption that may be worth examining. And there's a very interesting quote which I would like to draw your attention from Kautilya from the 4th century BC. This quote is symptomatic of the kind of institutionalized forms of corruption that prevails in India, but also in many other countries. But also it gives a perspective of how corruption is so deeply embedded in almost every aspect of what we do in this country, but also in other parts of the world. Let me just start with, this is the Global Corruption Report published a few years ago, and even in the current issue of the Global Corruption Report, we are ranked somewhere around 90s. This is a study by the Transparency International, and I won't go through the entire PowerPoint. I just want to bring a few issues just to give you a perspective of the kind of corruption that prevails. This is the problem. This report of TI is in relation to India itself. where it talked about the petty corruption that is deeply embedded in all aspects of the governmental service deliveries, and that's the kind of corruption we are talking about. These are some of the other countries we can quickly go through. My own view about this particular statistics of other countries is, if you're really above 50, it doesn't matter whether you are 60, 70, 80, 100 or 120, it's purely a matter of degrees. So there is no contention really about the fact that corruption is deeply embedded in every aspect of governmental exercise of power in this country, and that's something, the core of this presentation. What I hope to do is to, the book, a few years ago I published a book called Corruption and Human Rights, Comparative Perspectives on Transparency, Accountability and Governance. And one of the things that I've argued in the book is that corruption and the kind of corruption that is deeply embedded in the Indian society is a violation of human rights. Now, of course, I'm very conscious of making an observation of that kind, particularly after Steve Marx's presentation about the fact that are we moving into proliferation of rights. And I remember very well my doctoral dissertation advisor in Hong Kong was a professor by name Hurst Hannam. And Hurst is Steve's good friend, who is a professor at, now he used to teach at the University of Hong Kong, and now he's back at Fletcher School. And in my earliest discussions about this issue, Hurst told me something which I will never forget. He said, you know, Raj, do you think that all good things that we need to achieve in life should be seen from the standpoint of a human right? And of course I was very conscious in answering that question. But then what I began to think about is that there are a number of issues that we need to be, it ought to be framed in the context of human rights, which provides opportunities for citizens to assert and governments to take note of it. And essentially what the human rights framework does is that it provides an opportunity for citizens to engage with the government and the governments to become more responsible in their functioning. Now, of course, there are different ways to look at the human rights framework, and one of the ways by which the book and my own work argues is that the kind of corruption that takes place in India in relation to undermining the effort of Indian citizenry to seek the rights that are enshrined in the Constitution of India, but also the rights that are interpreted and evolved through the jurisprudence of the courts, is indeed a violation of human rights. And here there is an elaborate articulation in the book itself on how specific acts of corruption violates, undermines the ability to achieve civil, political, economic, social and cultural rights. Now, what I intend to spend a few minutes is to really think about why this approach is useful and relevant in the Indian context. Now, historically, at least for the last 4 decades or so, there have been significant efforts in relation to fighting corruption in India. Corruption has been recognized as a problem for a very long time now, and successive governments have attempted to address the problem of corruption. But there was one uniform theme in all these efforts, which is to strengthen the law enforcement machinery, to look at solutions which essentially involve creating new legislation or to create new provisions in existing legislation. Of course, we all know the Prevention of Corruption Act, as well as certain provisions in the Indian Penal Code, which were primarily the framework for fighting corruption. And the second big thing, or the big effort that was attempted to fight against corruption is to create institutional mechanisms in the fight against corruption, be it the establishment of the Central Vigilance Commission, before that, of course, the Central Bureau of Investigation, as well as the state vigilance and anti-corruption departments across different governments in India. But it is fair to say that all these attempts to create both legal interventions, legal mechanisms, as well as institutional mechanisms in the fight against corruption in India has been a complete failure. And one of the reasons why I believe these efforts have been a complete failure is because of the fact that India is not a rule of law society. As much as we have a semblance of institutions which are involved in ensuring that we have the rule of law, which includes the constitutional framework, a free and fair electoral process, which more undermines the democratic process, and also which has a framework of an independent judiciary, which is involved in the adjudicated process. However, when it comes to the core aspects of rule of law, we have still a long way to go. And so, because we are not a rule of law society, and I firmly believe so, attempts to use legislative and institutional mechanisms in the fight against corruption has not been proved to be effective. In fact, India is in many ways a unique nation where over the years we have been able to institutionalize democracy as a form of government through the development of democratic institutions, but also instilling a strong faith in the people of India in the democratic process. When good part of developing countries around the world are increasingly having situations where they are indifferent, or at times even people are slowly becoming impatient about the strength of democracy, India has consistently seen a situation where large number of Indians contribute to the electoral process. Even in the recently held elections, we have over 60-65% of our population participating in the electoral process. And this actually is also, this is the case even when a large number of Indians are extremely frustrated, outraged, disappointed with the functioning of the governments both at the state and the central level. But whenever elections are held in any part of the country, state or national elections, there is a large turnout. So in some ways, the Indian context is so unique because the traditional understanding of what democracy could contribute to is that democracy creates opportunity for the people to contribute to the formation of the government, and in that process seek greater transparency and accountability to the government. And of course, that traditional presupposition is challenged in India because with high levels of democratic process deeply institutionalized, not only at the national and state level, but also we know after the 73rd and 74th Amendment of the Constitution, we have the Panchayati Raj institutions and the Nagarpalikas institutionalized in this country, where democracy is going, there is a deepening of democracy in this country, while continuously we have seen high levels of corruption. The second related aspect is that because of the fact that we have not been able to establish a rule of law society, there have been two consequences in the fight against corruption and its implications in the fight against corruption. One is that we have seen a very disturbing trend of what has been noted as criminalization of politics. This trend for the last 3 decades has had a very deleterious impact on the nature and context of governance, both in the electoral process of the kind of people who are elected into the parliament, as well as the state legislative assemblies, as well as the kind of alliance that prevails between the criminal syndicates as well as the electoral representatives. In fact, several years ago, there was a report published by the then Home Secretary N.N. Bora, who is now the governor of Jammu and Kashmir, and it was called the Bora Committee Report. And the Bora Committee Report's primary finding is the kind of criminal nexus that prevails in India, deeply embedded, fully institutionalized across all levels of government. And he even said that a parallel system is virtually running the Indian state. And that could be a harsher and a more, critical observation. In more recent times, the National Commission to Review the Working of the Indian Constitution, in a report, in a paper, in one of the papers on probity in governance, had made a very similar observation that corruption is so deeply institutionalized, embedded in all aspects of governmental excess of power that slowly it is eroding the very foundations of state in India. And by the way, this is not a report of any non-governmental organization, or for that matter any international human rights organization. It is none other than the report of the National Commission to Review the Working of the Constitution, which was a body set up by the then government itself. I say all of this to bring home the larger point that the problem of corruption is probably the single most important problem in relation to the future of Indian democracy and its ability to fulfill the aspirations of the people of India. The second consequence which I mentioned, because of this and the fact that we have not been able to institutionalize the rule of law, we have a problem known, what I call, in my work as politicization of crime, in which the whole anti-corruption efforts in this country has largely been an effort to politicize and to be used as for the convenience of the governments in power. In fact, it's a very predictable pattern. Every now and then, when a new government comes to power, either at the central government level or at the state government level, there is a plethora of new attempts to investigate past acts of corruption, and prosecution of corruption attempts are made. By and large, the law enforcement machinery is compromised. There is little or no independence of institutions that are involved in the fight against corruption. And in many ways, people in India have pretty much accepted the fact that these attempts to seek investigation and potentially prosecution of corruptions is a sham exercise, and they have little expectations from that. They actually tend to believe more often than not that these are all politically motivated and there is nothing going to come out of it. And of course, the results are there for us to see. There has not been any prosecution relating to corruption in the last several years. Many attempts which were made in relation to the fight against corruption get somehow compromised, either because of poor investigation, tardy process, or for that matter, not adequate attention paid to the prosecution itself. Now, I say all of this to bring home the larger point that attempts to fight against corruption through legislative means have not worked, in spite of the fact that there is an anger and outrage and a large social expectations from the people of India to address corruption. In fact, very interestingly, elections many a time in India, in recent times in particular, are fought with a view to recognizing that the government of the day is actually highly corrupt and the new government will actually address the problem of corruption. And very interestingly, or rather not so predictably, once the new government comes to power, the issue of corruption somehow goes into the back. The new policies and frameworks and future dimensions takes over, and the issue of corruption, which was one of the most important reasons for governments to come to power, gets into in many ways it gets ignored. The problem which I mentioned just now is symptomatic of the fact that legal mechanisms, or what we understand as the law in this country, is not similar to what is understood as the law in many developed countries and in many advanced legal systems. So one of the most important things that we need to do with the view to fighting corruption is to move towards establishing a culture of the respect for the rule of law. And of course, this is a legal culture, and I remember very well when Professor P. Singh taught a course for us many years back as a student in Delhi University on comparative law. We discussed the kind of legal culture that prevailed in countries like Germany. And one of the things that was so, reflection of many of these societies is that the fact that there is this internalization of the respect for the rule of law, beyond the ability of law as a sanction, as a tool for individuals to regulate their conduct. Now that's the kind of movement that is needed for us to work towards establishing a mechanism which will in turn fight against, which will improve the quality of governance. Now, having said that, the last 2 decades has actually seen something quite extraordinary. Why I say is something extraordinary is that for the first time, the fight against corruption has been initiated not by the mechanisms of the state and the legal mechanisms that we are aware of, which is led by the state. In fact, the new age developments in relation to the fight against corruption in India is largely due to galvanization of civil society and mobilization of social consciousness with a view to fighting corruption. The establishment of the MKSS movement, and also a widespread people's movement with a view to moving towards establishing the Right to Information Act, and progressively establishment of the Central Information Commission and the State Information Commission, are all important pointers in the right direction towards what I call democratization of the fight against corruption, in which the institutions that are involved in the fight against corruption are focusing on the empowerment of people as the central aspect of fighting corruption and improving governance. Of course, it is relatively early in the day to make significant observations about the working of these institutions. However, it is fair to say that there have been serious and significant efforts with the view to bring the issue of transparency and accountability into the popular consciousness and imagination of civil society, including Indian citizenry. And this is actually led by, one of the interesting dimensions of this effort is it is not an organization which is leading it. It is sufficiently broad-based. It involves, non-governmental organizations, civil society organizations, people's groups, even at times bar associations, and a large number of enlightened citizenry spread across the country who are contributing in different ways to asserting the right to information, using the existing institutional mechanisms to approach the established mechanisms to seek greater transparency and accountability. And in many ways, throwing open the functioning of the government to public scrutiny. And that's a very important and a salutary development. And also, it is fair to say that the fact that there is near almost consensus among political parties somehow to undermine this effort is also a reflection that how the RTI is actually working. In fact, if you remember, a few years ago, there was a very strong attempt, and that even with so much of confrontation that was prevailing across different political parties on so many issues, but when it comes to undermining the functioning of the Central Information Commission, as well as to introduce amendments which will restrict the scope of the RTI, there was pretty much consensus prevailing across political parties to infuse those amendments. Thankfully, it didn't happen because of a very strong and vigilant civil society media which came out against those amendments heavily, and ultimately didn't happen. But there's always this threat of reducing and in many ways undermining the RTI itself. And now, of course, I am very conscious of the fact that it is one thing for the RTI and the Central Information Commission to throw open the functioning of the government, including the exercise of powers to public scrutiny through the right to information, but it's another thing to actually for it to engage in or for us as a people to see a stronger and a more independent mechanism to fight corruption and to make people accountable for their acts of corruption. Now here there are, one of the most saddest parts of the fight against corruption is that it is not going to happen soon. Meaning, highly corrupt societies all over the world have not transformed themselves in a few decades. There are a few examples I'll come back to briefly. But it takes several decades, if not even a century, for societies to move from that type of corruption that we have to a society which has seen lesser levels of corruption. A year and a half back, we at OPG Global University organized a conference on public policy, led by the Tyndall School of Government and Public Policy, together with the Goldman School of Public Policy at the University of California, Berkeley. And the Dean of the California School of Public Policy, Professor Henry Brady, spoke about corruption in the United States. And he mentioned something which I did not know of, and that was quite interesting, is that he compared the current framework or the current situation of the crisis of governance in India that we talk about in relation to corruption to 1910, 1920 United States. And he talked about it in the context of how deeply embedded forms of corruption was widely prevalent in the United States, and the kind of problems that we raised in relation to corruption was indeed prevailing there. Of course, that led to several decades of progressive but robust implementation of reforms, but also creation of democratic institutions in that country. Now we need to move towards that stage, and that is why one of the biggest challenges in the fight against corruption is the establishment of independent institutions. Unfortunately, we have a major challenge in this country with regard to establishing and ensuring independence and legitimacy and credibility of our institutions. We have suffered from what I have called elsewhere institutional decay and deterioration, and ultimately death of many of our institutions. And one of the challenges to contribute to the fight against corruption is to ensure that we are able to build such institutions. Now, I will quickly move to the contemporary effort to fight against corruption. We are all familiar with the entire movement, the Anna Hazare movement, and its attempts to seek an independent missionary in the form of Lokpal and Lok Ayuktas. What I have called elsewhere as the attempt to establish the Independent Commission Against Corruption in India. I will mention one example. I mentioned a few minutes ago that there's probably no society in the world that fight against corruption and the transformation of a highly corrupt society to a relatively less corrupt society has happened in a span of few decades, excepting in Singapore and in Hong Kong. And I will briefly mention about the Hong Kong experience, although I'm very conscious that using any experiences in societies which are so small and countries which are so small, and to draw that for the Indian context may not be suitable for a number of reasons. Nevertheless, it is useful to mention that the establishment and the growth and development of the Independent Commission Against Corruption in Hong Kong is a fantastic example of how it is actually possible to even imagine an institution which has worked effectively, and Hong Kong has seen in barely 2 to 3 decades, from a highly corrupt society to what it was in 60s and up till mid 70s and even late 70s, to a society which is now by and large clean, but more importantly has been able to be a beacon of inspiration for institutional mechanisms in the fight against corruption. But the two things that made Hong Kong possible was that Hong Kong developed entrenched system of the rule of law to ensure that corruption is not tolerated. And second, there was very strong political consensus consciously for all of what Hong Kong went through all those years. And the other example, and Hong Kong experience is even more telling for the Indian context, is that it was predicted in 1997 that when Hong Kong will be handed over to China, Hong Kong will once again go back to these high levels of corruption and nepotism and all of that, but it didn't happen. In fact, the government in Hong Kong continued to ensure that the institutionalized machinery that was created is effective. And today, the mainland government is increasingly looking up to the functioning of the Independent Commission Against Corruption in Hong Kong to draw their own policies and frameworks in the fight against corruption. Of course, there are challenges within Hong Kong which we will not go into, but I just want to bring home the point that there have been relatively few experiences in the world in which corruption has been successfully fought in a matter of 2 decades or so. When it comes to the Indian context, I mentioned that we need to, and unfortunately, the Lokpal bill and become an act, and now we have what is known as Lokpal as an institution. But even at that time, and have been continuously critical of what was passed in the Indian Parliament. What was passed was clearly not something which we should have done in the form in which it was done, because I do believe that institutional design is the most important aspect of any attempt to create an institution which is going to be effective for anything, and definitely for corruption. The current institutional mechanism which we have agreed upon under the existing legal machinery is clearly not only does not provide checks and balances that is needed in the fight against corruption, but does not even ensure a modicum of consensus, which will mean that the composition, functioning powers, as well as other aspects of the Commission has been undermined. And we know now that even after more than a year since the passing of the legislation, there is not even a minimal consensus to ensure that the composition of the Commission and the members as well as the chair is being able to be appointed, and we've been having a circus literally in relation to the establishment of the Lokpal itself. I will also briefly mention that the other critical aspect of the fight against corruption, which is in relation to improving the quality of governance as well as creating a faith among the people in the fight against corruption, is the need for whistleblower protection law. Unfortunately, we don't have a robust whistleblower protection law. At best, we have some guidelines from the Home Ministry, which has been obviously very ineffective in the fight against corruption, and we need to have a law which will instill that faith among the people that they can actually report acts of corruption, and their confidentiality and their own safety and security will be maintained. But that presupposes the existence of a mechanism which will ensure that corruption is not tolerated at any level of government. I just want to end by saying that the future of fight against corruption is increasingly going to see a greater role for civil society, for youth, and as well as for people who are spread across the country and are going to demand greater accountability on the part of the government. Of course, it is not going to come easy, but I do have some hope in this, largely because of the fact that we are going to be a young nation. For all the South Asians who are present here, South Asia is going to be a young part of the world, but India is going to be a very young country for a long time. We have approximately 800 million people in India are less than 35 years of age. 800 million people are less than 35 years of age. With life expectancy levels increasing, we are going to see a situation where good part of the world will become older and India will remain younger. And that also means that the young people of India will have a very critical and important role in the fight against corruption. They are not, I believe, going to accept status quo. They are going to seek innovative solutions. They are going to address the role of the government very differently. And that we have already seen it, and I do believe that that is going to be seen much more in the years to come. I will conclude by saying that it is all very depressing to look at everyday new forms of corruption being revealed in the country. At the heart of it attacks the moral foundations and the character of a nation. But it's also useful to mention that there have been two interesting and unique situations in which, in my own limited life, I have seen not just corruption reducing in India, but eliminating in India. So I am 40 years old. Like many of you are younger than me here, except my professors and mentors here. In my own, maybe less than 2 decades ago, if you recall, some of you might have been there. If you go to a railway station, you will find a situation where there used to be a person sitting in the front, in the entrance, and you ask for a ticket, and this person will most likely look at it and say there's no ticket available. And then you slip a 50 rupee or 100 rupee note, and mysteriously a ticket will emerge and you will be given a ticket. And that was a very commonly accepted direct form of corruption, where you pay a bribe and you get the ticket. Technology and use of technology in the form of train booking has not just reduced corruption but eliminated corruption in India. Of course, in Tadkar and a few other areas there are still some challenges, but today, just by the use of technology on rail booking, corruption has been eliminated. And of course, this was not done to fight corruption. The unintended consequences of use of technology in an important area of access to services has just eliminated corruption. And I am obviously mindful of the fact that the technology cannot solve all our problems of corruption. The second very interesting dimension is that 20 years back, if you want to get a telephone connection in India, you will have to either pay bribe or you need to know the telecom minister. It will take maybe 5, 7, 10, 15 years. You might have booked a telephone. And I remember after 7 or 8 years of waiting, when my parents got a landline at my home, they hosted a grand party for everybody in that locality. It was a very big celebratory moment. Now today, privatization in access to telecom services, I'm not talking about 2G and 3G, where there is obviously corruption. But access to telecom services, we have not only reduced corruption, but we've eliminated corruption, because if you want a telephone connection today, 10 guys will be after you and you'll get the telephone in 24 hours. So the point I'm trying to say is that, and of course, privatization again is not a panacea for all ills. Privatization and use of technology in these two areas are examples of the hope that the future can hold if we can find out innovative approaches to improving the quality of governance and creating transparency and accountability. But nothing can substitute us from moving towards establishing a society which respects the rule of law and those who are engaged in acts of corruption are conscious that they will be subject to accountability and they will be booked under law. And here we need to constantly be reminded of Cesar Beccaria, who talked many years ago about the need for ensuring certainty of punishment as an answer to crime prevention, as opposed to severity of punishment as an answer to crime prevention. And here we need to focus on a situation where we are able to ensure even smaller punishments for people who are engaged in fight against in acts of corruption, rather than large punishments, but the fear that if they do engage in acts of corruption, they are bound to go to jail for a short period of time, is going to create a better amount of sanction and disincentive for people to engage in acts of corruption. I would like to stop here and thank you to South Asian University and Mr. Yogesh Tyagi, and indeed in memory of Mr. R. P. Anand for all his extraordinary contribution and the source of inspiration that he had given to many of us by his work and his life. Thank you.
It occurred to me that just as a very small footnote, one of Professor MP Singh's students collaborated with me on writing an article about the former Minister of Tourism of Karnataka, who has been serving now 3.5 years in jail for illegal mining. I thought that was a very significant demonstration of the ability of the criminal law, only rarely used, to incarcerate a serious wrongdoer and profiteer. It's come out last month in a journal called Environmental Law and Policy for students. Okay, now we'll hear from Professor Manoj Singha, who will talk to us about international human rights law.
To spend time with Professor Anand as a student in 1990, when I was a student of a Master MA program in Jawaharlal Nehru University, and subsequently he became very good friend of all of us, in fact, and we visited many times. Professor Anand was not equally good in international law, he was equally good in Hindi. He was in fact, he wanted to become a Hindi teacher. And he remembers all the poems, so he finished his bachelor degree in 1949. And many times I used to go to his home, and he used to narrate me Kabir and everything. He said, no, and it's very good memory. So he said, Manoj, I read everything in 1949, and what I am repeating today, it's in my memory. So very sad. And he is also very fond of collecting the materials wherever he go. And one interesting story he told us, he was returning from Germany and carrying 2 heavy bags. So custom people stopped him and said, what you are carrying, all these documents? What you have, you brought from abroad. Then in Hindi he said, nahi, bhaiya khali kagaz hai, paper, there is nothing else, only papers I have collected. They did not believe, 2 heavy bags, and what is this old man is doing carrying from? So he asked them to then he said, okay, you have to open. So he opened it, and then finally they saw that papers are there, a series of articles he photocopied, and that was kept in the bag. He said, why, professor, you have to travel all the way to Germany to collect all these papers? You could have easily got in India. But then he told me, you can't understand all these things. But he used to, wherever he visited, he collected the materials. And the last meeting I had with Professor Anand in year 2009, that time he collected a lot of materials. He is very fond of the African studies. And he had a series of, and that in 2008 he was in Germany. He got a series of articles on the African perspective, and he wanted to write a paper. And then I met him, and he said, Manoj, it seems I can't write now, I'm getting old, but I have collected huge material, I have soft copies, I have hard copies. Then out of curiosity, I said, sir, why don't you give me all these things? and I will try to see one day I'll write. So he gave me everything. It still is in my computer. And but I have not done anything, but I promise I'll try to write something, 1 or 2 articles out of the material which I have. He handed over to me, so one thing is there. Another important point about, like, each day we discuss about the UGC and the Ministry of Human Resource Development, how to improve higher education in India. And there are a lot of suggestions keep on coming. But I believe if UGC takes note of Rajkumar, then all problem will be solved. How? Because he has so much freedom. The moment he realizes Stephen Marx is very good, so this, like, I got an opportunity to interact because of Rajkumar. I got an opportunity to interact with, not they are coming here, they are spending time. But if I want to do in my university, or if Professor Tyagi sir wants to, or any other vice chancellor, then they think, why we need this person, how much money, there are a lot of paperwork, and finally we freedom. I remember, and many of our colleagues are here, Professor Robert Barney, his term was over. He wrote an email, collective email to all the teachers, Banaras Hindu University, me, and all the teachers. He said, my term is getting over from the University of Reading. I want to come India. I will not charge any money, but you provide me accommodation, and so I will be there 1.5 years. So I am willing to come and discuss about the international law. That will be a good idea. Only a place to stay, food to eat, and nothing else. He was asking. He said, travel cost, everything I will bear. He was so nice. But we all failed. Only person who tapped, Rajkumar has tapped him. He paid him also. He is not food, shelter, and he has given remuneration also. So he extended his stay. So that's very good. Like, this opportunity to be given, the amount of freedom is required for the improvement of higher education. And also we had an opportunity with Professor M.P. Singh when he was the Vice Chancellor in our university. He brought very eminent professors there, and somehow, students were benefited, we all were benefited. So this higher education, amount of freedom is required, that is needed, and I hope that the government will take note of this. Coming to the point, which takes me back to the whether actually human rights proliferation is taking place. That is the question I have in mind, and this was also raised last time when Professor Chimney was there. He also raised this question concerned about the proliferation of human rights. And what I did, I just personally looked into the normative framework which we have officially recognized and put on the website of the Office of the High Commissioner for Human Rights. I see there are 9 international human rights instruments are there. Out of 9 international human rights instruments, particularly only 2 instruments, if I am right, adopted in 21st centuries. One is the on the rights of disabled persons, and most probably the second one is the enforced disappearances, if I am correct. Except these 2, these 2 were adopted between 1974 to 1990. And prior to 1974, so most of the human rights instruments, so actually 2 instruments adopted in out of 15 years, we see only 2 instruments were adopted. Rest of the instruments were adopted between 1974 to 1989, and only 2 instruments which are part of International Bill of Human Rights, which started from 1948 and finally got adopted in 1966. Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, Economic, Social and Cultural Rights. In reality, adoption of new instruments are in human rights field, it's little bit slow. It's not proliferation is there. The problem is more in the effectiveness implementation part, which will come later to discuss about that. However, in all human rights instruments, what we see, protocol has been adopted time to time, like Convention on Elimination of All Forms of Discrimination Against Women. Individual complaint mechanism was added in 2000. CRC also added 2 instruments. So protocol has been added in the existing human rights instrument. However, some new areas have emerged where concerns expressed by the scholars, international organizations, individuals, how to tap, how to bring them under the human rights umbrella, governance, global governance, governance and human rights has become a very important subject in the late 20th centuries and beginning of the 21st centuries. Another important area which we see, that is the 21st centuries, business and human rights. Now in year 2011, Ragi's principles have finally adopted. So new areas have been adopted. Even right to health, it was there under the human rights instrument. But all of a sudden it figured extensively in the discourse of the human rights. It started from the TRIPS agreement, Doha Declaration on then right to access of the cheap medicine has become a global concern, and series of dissertation, PhD, MPhil people started on working. Earlier in early 80s and 90s days, we talk about the civil and political rights and everything. Even if proliferation has taken place, it's good. It's good in a sense, corruption, United Nations Convention on Corruption was adopted, so that has compelled government of India to think. Convention against torture, India is not party, but India has already, a bill is pending from 2010 on the prohibition against torture is there. India is not party of the Convention against torture, but interestingly, Government of India has mentioned in the objective and purpose of this bill that India is party to the Convention against torture, thus there is a need to adopt a national law. That is good development, so we are thinking about on that particular count. So we see, ultimately international human rights instrument, it gives you a framework and asks each sovereign state to implement at the national level. It gives enough space to the independent states to implement. And what do we see when they fail to implement, whether these international human rights instruments are effective enough to push a state to comply with the provisions mentioned under the convention, which we see in some way it's very weak in the instruments if we go into that particular direction. Now coming back to so I believe that that is the subject of discussion, and maybe we are in this different marks, if we get some opportunity we'll share about that. Another important human rights instrument, the idea which I had in the beginning to begin with, that release of Peter Gaster, is the Australian journalist. Just day before study, he was released from the Egyptian prison. He was in jail for almost 400 days. And there are two other colleagues, it is still languishing in the jail. What was the crime they committed? They have just simply reported. They were journalists of the Al Jazeera. They reported something and they put behind the bar. And they were tried and 7 years conviction was given. But a lot of negotiation, so human rights diplomacy entered there. A lot of international pressure was there. So in month of December 2014, Egyptian government said that they are going to retry. But however, things moved very fast and he is finally released on just a couple of days back. What he has done, simply he has reported what happened in the ground level. But Egyptian government says, he is a supporter of the Muslim Brotherhood, one. Second, he is threat to the national security. How this journalist is a threat to the national security? That is the question to be answered. The another important, which also very interesting development, freeing of the city of the Kobani in Syria, that has been just liberated. But what is there? The entire city has been flattened. It's not and in fact it has been compared with the destruction which was caused in the Nagasaki and Hiroshima. They know what the entire city has, so entire international humanitarian law, if we do, protection of civilians, it's gone under the Kobani. But still people are happy. Those who were there, they want to come back and rebuild the society. That's the two important development we have on that particular count. Now coming to the 21st centuries, whether some development has taken place in the 21st centuries in the field of the human rights, which I want to answer in through the development, starting with the Millennium Development Goals. So what has been realized in 2000, the human rights problem will be not resolved or not solved if we fail to take care of the extreme poverty. So that has become a global concern. And in year 2000, many of you are aware that Millennium Development Goals, even General Assembly has adopted Millennium Development Goals. And out of this Millennium Development which was adopted, it sets a target that by 2015, the poverty population will be half, and by 2025 it will be removed. And to assess the progress, how much they have achieved, each 5 years, like outcome documents in 2005 and 2010, that millennium outcome of the Millennium Development Goals took place. And target, it seems little bit like, it's in some area they have achieved, and they found it's very difficult to achieve. So finally, Millennium Development Goals, which has 8 important goals. In year 2012, the Secretary General of Ban Ki-moon, he appointed a high-level panel committee of 27 members to advise him on the global development framework beyond 2015. So today we talk, this like in human rights discourse is very important, and it's very important today because it's a new development post-2015 development agenda. Post-2015 development agenda, that has become a very important, and recently also on 4th December 2014, the Secretary General of the United Nations has submitted a report that says the road to dignity by 2030, ending poverty, transforming all lives and protecting the planet. This is the recently on 4th December 2014 Secretary General of, and it has 6 essential elements which I want to discuss later. Coming back to so this 27 members panel with Indonesian president, even David Cameron was the member. They submitted a report finally on 2013. And that is called as known as, so maybe not many students can look into because we miss in human rights classes, these kind of things. A new global partnership to eradicate extreme poverty and transform economies through sustainable development. That report has been submitted and it has identified, so it is a shift from the Millennium Development Goals to this particular new global partnership. And they suggested 5 important points which were addressed. The first is, leave no one behind. So first, leave no one behind, which means to have faith in the original promises of the MDG. What is the original promises of the MDG? To eradicate extreme poverty from the earth planet. So this has been reiterated under the high-level panel which submitted a report, identified 6 core areas and says, leave no one behind. It emphasizes, keep faith with the original promises of the MDGs and finish the job. So initially the job was targeted to finish by 2025. Now it has been extended to 2030. So by 2030, you finish, you take care. And this is a global responsibility, that is, leave no one behind. That is the first promises of there. The second, now it's very important, which some of our friends are environmental experts. This time Rio plus 20s, sustainable development, those principles have been also incorporated, and they say to put sustainable development at the core, the second agenda of this. Third, transform economies for jobs and inclusive growth. So it talks about whether developments which are taking place at the national level is inclusive or not. That has also been reflected here. It focuses on the third point, inclusive growth. Transform economies for jobs and inclusive growth. And fifth, fourth, to build peace and effective, open and accountable institution for all. And last, which talks about to forge a new global partnership to forge a new global partnership that is there. These are the 5 important points which a high-level panel which was constituted by Ban Ki-moon in 2012, they identified, which is more or less reiterating the commitment which was made by the international community in 2000 under the Millennium Development Goals. Secretary General of the United Nations also submitted a report recently, which I mentioned, The Road to Dignity by 2030, Ending Poverty, Transforming All Lives and Protecting the Planet. It has also 6 essential elements for delivering on the Sustainable Development Goals. It identifies, again the same way, to end poverty and fight inequalities. So Secretary General on its own report, it gives emphasis on to end poverty and fight inequalities first. Second, it talks about public health issue as well, to ensure healthy lives, knowledge and the inclusion of women and children. Third, to grow a strong, inclusive and transformative economy. And fourth, to protect our ecosystem for all, societies and our children. And last, that is related with the justice. It says to promote safe and peaceful societies and strong institutions. So what we see, these are the agenda which has to be taken forward now in 2000. So this is a development which has taken place in the last 2 years. Now a time has come, now international community, international organizations, international institutions are going to take it forward. To conclude, I strongly believe that we must support the development of the international human rights law and try to see wherever the gap exists that needs to be filled. There are a lot of challenges, lot of difficulties in implementation of human rights by the state parties at the national level. But interestingly, like Mr. Marx and many of you are aware, that Indian judicial system, which Rajkumar, I don't know how far, because he has identified the rule of law is a little bit weakened in Indian scenario. But whenever we go outside of the country, we start with this, that Indian judiciary is very strong and appreciated for that. So our discourse starts, so even if you go for the international law teaching or the lecture, people are more keen to know about the role of the Supreme Court and High Courts in India in development and protection of human rights and environment, and we also feel Article 21. So we, in that sense, Article 21 we have excessively developed. That is the problem which we see here, and that leads to some kind of problem in implementation. With this, I believe that let it continue, and if this will continue, then world will be a better place to live, and human rights of all individuals will be protected. And thank you very much.
Questions, answers, back and forth. Let's get somebody. Everybody should have at least one item to share. Everybody in the whole room. You. What would you like to share?
Yes, sir.
Yeah.
I would like to say, sir, like as Sri Rajkumar sir said, and you also said that a former minister has been jailed in India. Like in Nepal, I am from Nepal. LLM second year, in Nepal, sir, there is a constitutional body since our 1990 constitution. We have abuse of authority, investigation of abuse of authority. It is a constitutional body. So its work is to charge the corrupted any corruption matter. So due to it, like former Home Minister, our former Information Minister, like head of police, they have also been jailed, and it is doing a good work in Nepal for the elimination of corruption.
Thank you. Yes.
My My name is Prabhash Ranjan. I teach at the South Asian University. My comment is inspired by the presentation of Professor M.P. Singh and also Professor Rajkumar and Professor Manoj Sinha, who talked about rule of law. In last few years, there has been this growing concept of international rule of law, which is distinct from the understanding, a bit distinct from the understanding of rule of law at the domestic level. Now, scholarly opinion on this question is divided, that do we indeed have something like international rule of law, because that would take us closer to the questions of constitutionalization that Professor Singh talked about. I have done some research trying to examine whether international investment law, the area in which I work, has any element of international rule of law. Now, I think all of us will agree that one element or one possible element of international rule of law is that certain restrictions are imposed on the exercise of sovereign power of host governments. In constitutions, we have the constitution which provides those restrictions, and we have the constitution which provides individuals direct right to hold the states accountable if their fundamental rights or other constitutional rights are violated. Now, if we apply the same to international investment law, we see something very interesting, that we have these bilateral investment treaties which restrict the sovereign power of the host state by imposing certain restrictions. For example, you cannot discriminate a foreign national investment in favor of foreign investment or vice versa. You have to treat foreign investment in a fair and equitable manner, etc., etc. And secondly, it gives private investors, which means private individuals, the direct right to bring a claim against the sovereign action of the host state, which is pretty unprecedented in public international law. So, if we take these as the two possible components of international rule of law, to a large extent they are satisfied in the field of international investment law. It would be very interesting to conduct the same sort of exercise for other spheres of international law and to see whether these are met in other spheres of international law. So, what I'm trying to say is that there is a kind of a movement towards the constitutionalization of international law. But this is not without its own controversies, because recently, for example, there have been instances where states have decided to contest the international investment law regime because they think they restrict their power too much, which is much more than what they would like to have. So there is also a tussle going on between what kind of restriction should be there, or what should be the limit of the restrictions imposed on the ability of host governments. This was just a thought that I wanted to share for larger discussion. Thank you.
Good, thank you.
Morning, sir.
Also about expropriation.
Yes.
Yeah.
Morning, sir. May I have one question, please?
Yes.
Morning, everyone. My name is Bushra Tariq. First of all, I would like to thank all the panelists for enlightening us today. My question is from Professor Marx. Professor, sir, on the international plane, we see a great deal of conflict between different human rights, different rights. For example, right to development and right to environment, right to abort and right to life. So in this context, should we completely abandon the human rights and we should stop the further proliferation of human rights? And if yes, then what are the other options that we have to resolve this conflict between human rights? Thank you very much.
Answers right away, or do you want to take it around?
Does anybody else have anything to say about that range of subject?
This is Mustafa Hussain. I am research scholar in this university. I am from Bangladesh. My question is Professor MPC. When we are talking about the constitutionalization of international law, the very much challenges we face first is the structure as it exists in international law, the system of Security Council, which is beyond the national equal sovereignty. There, for instance, I don't think we'll be agreed to the point of having a system. Second important thing is what is the fear of developing third world countries is, as the international law is a good centralized from the Eurocentric of centricism of international law. The problem is that these countries will be concerned that whether in future, if constitutionalized of international law, the same influence will remain. And most importantly, what further is
significant here is that the countries of Asia and other parts will be concerned about their culture, because when we are talking about the constitutionalization of international law, the very fundamental question arises there about the relationship between international and domestic law. In order to constitute international law, the domestic law has to be complied with. The lectures of Antonio Kesase in Hague Academy, he pointed out some examples of European Union where some Western Europe, particularly the constitution of Germany, as well as some Scandinavian countries, they have in their constitution included the provision where they extended their sovereignty to an international organization. But that is to a regional level. On the question of having an international body of that kind, the second issue is the socialist group, where Antonio Kesase has taken all the modern constitutions, divided into three groups. One third world countries, one socialist countries, and the other is of the Western centric countries. The problem which we face in this part of the world is that the state constitutions even don't include international law's application within the fundamental rights part or some other part. They just include it only the fundamental principles part or principles of state policy part, which is not justiciable. In all these existing concerns, what can be, but my individual comment is that at regional level, states can think of such kind of mechanism. For instance, in SAARC, all countries have almost similar cultural affiliation, and most of them are based on common law tradition. So if some regional instruments can be initiated to extend sort of sovereignty by establishing a regional mechanism, to some extent that will work. And when all over the world the regional system will work, perhaps then for a global system can be think of. Otherwise, it seemed kind of very much challenging whether states will be agreed to that point. And that's my observation. Thank you.
Anyone else? Yes.
My name is Zahid Rahim. First of all, thanks all for attending the session. I have one reality to share and a question regarding that reality to Professor Stephen P. Marx. And the reality is that international social service, for example, health facilities towards human beings and also opposition towards its through arms business and drugs mafia, is controlled by one richest establishment of the global world through global monetary capital, which always goes in favor of developed countries and ruin the developing and underdeveloped countries. So my question is that how this problem can be solved in such a way that complete justice for all the human beings of the world. Thank you very much.
Reception we have here, and the man we're honoring here, this is oversight on my part. Of course, I meant very much to do that. I'm deeply moved, and I'm actually wanted to point out that I'm wearing a tie that comes from the university where we were together when we first met with C. Raj Kumar. Many things were said and several direct questions, but one of the points that I wanted to make is that I think yesterday at the Center for the Study of Developing Societies, Rajni Kothari was honored, and he was honored previously at the Gandhi Peace Foundation for his work. One of the things that he did brought to mind the constitutionalization issue that you're talking about, and that is his contribution to the World Order Models Project. One of his books in the framework of the World Order Models Project was called Environment and Alternative Development. And it reminds me of the theme that our chair is a world leader in. Conceiving of the problems of the environment and development, alternative development, in the context of world order, by which the scholars involved in the WOMP, the World Order Models Project, including Rajni Kothari, were looking profoundly at the issue of the constitutive elements of a world order that would provide for the 5 world order values that they had identified. And frankly, I think we have not moved very far since then in conceiving a world order. Now let me relate that background thought because of the significance of Rajni Kothari and of the WOMP project to the theme of Singh's presentation, and come back to the other questions briefly that were raised. One of them was quite specific about whether or not the way I referred to and the way I provocatively inserted those quotations from people who denounce the proliferation of rights. Those are right-wing people who haven't got a clue what human rights are all about, who don't know half of what all of you know about the human rights framework, that don't haven't benefited from the teachings of Monar Sinha. And in particular, he was quite right to remind us that the principal treaty norms of human rights are the 9 core instruments of the United Nations, only 2 of which were adopted in the 21st century. Those are indeed the treaty norms. So the question was put to me is, what about the right to development, the right to the environment, right to an abortion, right to life, and so on? Should the proliferation of these rights lead us to do, as some of those authors that I quoted at the beginning deliberately, provocatively, lead us to throw up our arms like Fukuyama did and said maybe we should call an end to human rights proliferation and end the process? Of course not. Of course not. As international lawyers, we have a regime of treaty norms that are expanding in the directions that I tried to describe. These are useful. These are means of implementing. These are means of taking one sheet of paper or a page and a half, which was the UDHR, and is now expanded into several volumes of normative instruments with mechanisms to monitor the application. And that includes the right to development, and that includes the right to a clean environment, and that includes the right to abortion. That includes all of the other domains that are expanding in different jurisdictions and in different ways. And that is why I think the continued teaching of international human rights as relevant to the practice of law domestically and internationally continues to be important. I want to link that to the point that was made about rule of law. I think your question on the rule of law was extremely pertinent. When you teach this subject in the context of international relations theory, regime theory becomes pretty useful here. And if you look at regime theory, you're examining the goals, processes, and actors that describe an issue area. Human rights is one of those issue areas. But you put your finger on one of the issue areas among 2 of the different regimes that function internationally, namely international investments. And the other one I would put in the same category is the international trade regime, where the norms, processes, and actors happen to benefit in the processes area rule of law, where the rule of law really functions, where there are real sanctions, real behavior is modified on the basis of the rule of law. In human rights, let's say they've achieved 98% of having norms that are established, actors that want to implement them, and a process by which the rule of law is implemented. Let's try to speculate a little bit. I'd like you to join in on this. In the regime that you described, we're probably around 98%. You step out of the norms, somebody is there to jump on you, have a procedure that will lead to results, you'll pay, you'll modify your laws, and so on. Human rights might be 30%, 40%, if you look at violations of human rights and what happens. The international environmental regime, I would turn to my colleague to ask, where would you place in the extent to which rule of law is actually a functioning process in that regime of the international environmental regime. It's a way of thinking at it in which we can say all regimes have norms, processes, and actors. And what we are aspiring to in the human rights field is to have the rule of law, that is, the process domain of the regime, attain a level of effectiveness that approaches that of international trade and international investment. I don't know if this makes sense, but that's what your comments inspired to me. I hope I've addressed most of the questions that have been raised. Oh, there was one about, yes, drugs, global capital, and so on, and how are we going to achieve global justice for all people? Well, that's really what it's all about, isn't it? We're trying to ensure that sovereignty in states is conditioned sovereignty based on compliance with norms of the international system. I come back to your constitutionalization. Norms of the international system that increasingly constrain sovereignties in ways that can prevent genocide, achieve development, and so on. So yes, a goal of global justice, of resolving the problems of all of humanity, is not to be totally abandoned, but it is to be pursued in ways that are consistent with the state at which each of these international regimes finds itself. Frustratingly, it is the trade and commerce regime where the rule of law has attained the highest level. Our goal and the goal of youth, as you proceed with your careers, is to bring the international human rights regime, the international environmental law regime, and the other regimes up to a similar level of effectiveness.
Yes, thank you, Prakash, for your comments and also friends from Bangladesh. Yeah, to your comment, Prakash, of course, there would be objections against rule of law. They happen within the state also. And therefore, there is every possibility that they would be happening in the international field also. But as I said, within the state, there are some conditions which are satisfied, which are not yet satisfied so far as the international community is concerned. And the conditions are that we as equal citizens indirectly or directly participate in making our norms, and also the system of enforcing of rule of law, that also is said at least to be consensual. And then the third condition of a kind of civil solidarity among the people, that is also satisfied. So the what is called as the requirements of democracy, they are satisfied, in which people are supposed to be agreeing on some minimum core values. That actually doesn't happen even in respect of norms which are made for treaties, and therefore the countries which find themselves in a disadvantageous position because of those norms, they would definitely be raising objections. And therefore, the international law or organization has to be so arranged or organized that these possibilities are excluded as far as possible. This is just my response to your comment, and so far as our friend from Bangladesh is concerned, actually, I myself admitted that so far as the European model is concerned, and actually European values are also concerned, generally even with respect to human rights, sometimes it is said that they incorporate Western values or European values, and they may not apply exactly so far as the other societies, and especially Asian societies are concerned. And some years back, 92, 93, in Bangkok, there was a conference of the Asian countries where they talked of Asian values and therefore not being bound by everything that the Western societies are deciding as human rights. Singapore even passed a kind of resolution from its parliament stating what are the Asian values, and those values have to be observed by all members of Singaporean parliament as well as by the people of that country. And therefore, there may be disagreements so far as these values are concerned. Yes, while in considering the international society, this question would always come, that if in philosophical sense you are conceiving a cosmopolitan society comprising the cosmos, then of course you will have to agree on some minimum core which you consider that even if it is not being followed so far by some sections of the society, they are worth following, and therefore they must also follow them. And for that reason, whether they are Western or they are Eastern, you have to actually agree on certain common theme or common values. And unless that kind of agreement is reached, of course, we don't make our constitutions. Maybe that in the constitution we have put certain things which represented dominant opinion, but ultimately it is considered to be an arrangement which we have all accepted and agreed. And even if some don't agree, through rule of law we have to ensure that they are made to agree to it. Now, it is that kind of conception which has to be developed. I am not hoping that it would be developed in a day or two. I am very glad, however, that some kind of engagement is there on those lines. And therefore, I am thankful to you that if you are pursuing that argument, which has to be taken into account when we plan to do something like a world government or constitutionalization of international law. There is one comment with respect to Rajkumar. Rajkumar, you may have noticed that a few days back in Times of India, it is I think January 30th, there is an article titled The Business of Honesty. It's corporations rather than government that can really help fight corruption. And the authors are Kaushik Basu and Avinash Dikshit. And they say there is a fundamental flaw in the popular expectation that government will have an interest in controlling corruption. Most agents who comprise government, politicians, bureaucrats, law enforcement officers, benefit from corruption. Therefore, laws are watered down and leave loopholes. Enforcement of anti-corruption measures by one branch is obstructed by others. And therefore, they suggest the solution lies with the business community. They say the business community as a whole has a stronger incentives to counter corruption because they are adversely affected by state corruption. Thus, business as a whole can benefit from the reduction of corruption, and therefore it is they who should take appropriate steps in that direction. I don't know whether you have ever thought on those lines.
Raj Kumar.
Thank you very much, sir. I'm familiar with Professor Kaushik Basu's work, and even his previous work has talked about, in one of his moments, he even said that we may have to think about legalizing bribery or something to that effect. So, I with all due respect, I don't subscribe to that view for a number of reasons. First of all, I do believe that, it will be a mistake to assume that any stakeholder in this entire framework of corruption is at all times only either a beneficiary or a victim. So, for example, if corporations are engaged at times are affected by widespread corruption, we know that corporations also are engaged in acts of corruption. The second thing, which is very important, is that this whole idea of somehow we take the corruption debate to the market, and the market forces will figure out the problem, and whatever suits in that marketplace will ultimately support and help the government to have agency, has not worked anywhere in the world. Even in the East Asian context, many years back, these arguments were made, and unless and until we improve the quality of the functioning of the government, we will not be able to, address it. What I did tell in a presentation, which I'm even more, conscious of, is that the issue of corruption is also about, I mentioned briefly about character, and there, very good work which I am recently profoundly inspired is the work of Professor Michael Sandel, who is a moral philosopher at Harvard University, whose book, a recent book titled "What Money Can't Buy: The Moral Limits of Markets." And in that book, what Michael Sandel has argued is that increasingly we are moving into a society where everything is up for sale, and we have looked at, he talked about, and he differentiates a market economy from a market society. And he supports the idea of a market economy but has problems with the market society. And in that society, in a society where everything is up for sale, he talks about the two consequences of that society is inequality and corruption. And unless and until we address these two issues, we will not be able to develop a society that will promote tolerance, and no other institution is better suited to the government itself to address that, while it needs to be supported by all stakeholders, including citizens as well as corporations.
And I'd like to say something in addition to that. We talk about governments, and it's quite clear that governments are not international governments. They're national governments. International human rights law, international health law, international environmental law, and so on are not self-enforcing. They rely on governments. All of them. They all rely on the governments to enforce these norms. Now, the norms there can be enough accretion of norms that eventually the governments recognize, as the case is with universal norms, Jus Cogens kind of things. But that's a very rare exception where everybody in the world accepts customary international law. Otherwise, you're really dealing with an exception here and there. The European Union is kind of an exception. The European Court of Human Rights is sort of an institution that deserves recognition. The Inter-American Court of Human Rights tries to do the same thing, though not very successfully. But largely, these trade and commerce and investment areas and the reliance on market performance tend a little bit to be captured by that community of whose interests are served. And they're not necessarily the interests of all the rest of us. They're the interests of those people. They have an inordinate degree of influence in the U.S., a good deal less in the EU. Some influence of that kind seems to be present in India and in China and in Brazil. Just remember, domestic enforcement is essential for all these international norms. Is there any other pressing question that, yes?
Hello. I have a drawing from the presentations of Professor Semianr and Professor Mark. I'd like to say that South Asia constitutes one of the largest populations of poor in the world. And there is no doubt that poverty will definitely undermine the standards of health in a region. So, drawing from this, I would like to seek comments from both of you. On the phenomena of feminization of poverty and right to health. Thank you.
Any others? We're running out of time, but we have room for one or two more pressing issues. If not, would you like to respond?
It's an extremely broad and extremely pertinent question. The feminization of poverty and the extent of poverty in South Asia are social phenomena that should be guiding the Sustainable Development Goals. I wanted to thank you for drawing attention to the context of the post-2015 development agenda. One of the things that you didn't say, but at least didn't come across in your references to that, and I'll bring it back to feminization of poverty in a minute, is that one of the painful lessons of the entire experience from the Millennium Declaration in 2000 and the bureaucratically defined Millennium Development Goals of 2001 and the experience of attempts to implement those goals has been the mobilization of the human rights community, including the High Commissioner for Human Rights, to try to draw attention to the significance from the human rights perspective of the Millennium Development Goals and the utter failure to draw upon the mutually reinforcing character that a human rights-based approach to development can have in realizing the development goals. This is a complex story, but part of it is that the efforts of many scholars, many civil society organizations, the High Commissioner herself, and I'll give him full credit, the Secretary General, has been to say, let's do better the second time around. And in fact, the 17 goals that have been defined so far by the open-ended group, notwithstanding some positive things by several of the bodies that you mentioned, including the High Commissioner and the Secretary General, have failed once again to draw adequately on the intersection between human rights and these development goals. So far, it's a failure. I don't expect a miracle between now and next September when the final version is adopted. I think the die is virtually cast. 17 goals are set. They're technocratic, bureaucratic goals, many of which are quite important. But they do include issues that are extremely important to the feminization of poverty and to the particular needs of women and girls in the context of development. And I think that is where international bureaucracies, national bureaucracies, civil society organizations can address the issues that you mentioned by deliberately taking each of the relevant sustainable development goals that relate to poverty, that relate to rights of women and girls, that relate to education, that relate to all of into urbanization, slum areas, all of the areas where poverty manifests itself in the particular domains where it affects women and girls, and reinforce efforts to improve access to resources and infrastructure to improve the situation. Reinforce those efforts with efforts to deal with rights of women and girls from a human rights perspective. And that's where the Sustainable Development Goals are weak, and that's where action by civil society organizations, international bureaucracies, and national bureaucracies can make a difference. So this is only opening the door to the answer to your question. The answer to your question, of course, requires a more detailed analysis of what are those rights of women and girls that are being neglected in the context of poverty in South Asia and elsewhere. But my linking it to what Manoj said is that there's a enormous struggle that lies ahead in the post-2015 development agenda to draw the full strength of the human rights regime to ensure that the feminization of poverty is reversed, and that as development goals are advanced, the rights of women and girls in the context of development in South Asia are also advanced.
Thank you. We've now come to, I'd like to ask Professor Tyagi to offer felicitation of Admiral Sharma for donating his library to the South Asian University.
All good things have to come to an end, but before we formally conclude the seminar, it is an honor and a privilege for me to propose a vote of thanks. Let me begin by thanking Professor Arvind Rosenkrantz for very ably chairing and moderating the session, and also for agreeing to come to South Asian University at such a short notice. We are indeed grateful to you, Professor, for sparing your time and coming to South Asian University. I'll request Fatima, a student from Maldives, to kindly present a small souvenir to Professor Rosenkrantz on behalf of South Asian University. Thank you so much, Fatima. I would now like to thank Professor Stephen Marks for his very useful intervention and commentary on right to health. We are indeed grateful to you, Professor, for agreeing to come to South Asian University and for making a very useful contribution. I'll request our student Rahul from Nepal to kindly present a small souvenir to Professor Marks on behalf of Faculty of Legal Studies. Next, it is my privilege to thank Professor M.P. Singh. Like Raj, I have also been a very proud student of Professor M.P. Singh at Delhi University. I would like to thank him. Despite his initial reluctance, he kindly accepted our request to come to the university and speak. Thank you so much, sir. I'll request Moinuddin Alamin, our student, PhD student from Bangladesh, to kindly present a small souvenir to Professor Singh. Thank you, sir. Who I agree with Professor Sinha has indeed revolutionized Indian legal education. Thank you so much, Raj, for your very passionate speech on corruption and for agreeing to come to the university. I'll request Janaha, our student from Sri Lanka, to kindly present a souvenir to Professor Raj. And last but not the least, I would like to thank Professor Manoj Sinha. for his very useful intervention and for his usual support to South Asian University. I'll request Fawad from Afghanistan, our LLM student, to kindly present a souvenir to Professor Semianr. I would also like to thank our Dean, Professor Tyagi, for his very able leadership, to all my faculty colleagues, all students. Most importantly, I would like to thank Mr. Ramachandran, who has worked very hard for this seminar. Also, Ramesh ji and Mr. Amit Rawat, thank you all. And thanks to all the students for coming to the seminar. I now invite all of you for a